Yes, Ms.
Thank you, Chair. Advocate Johnson, before we adjourn for lunch, we had just completed your second statement. Correct. Before we turn to your third and last, just to check, is there anything else you'd like to add or perhaps clarify, highlight as regards the second statement, or you're okay?
If I would be allowed.
Yes.
On the example that was put by one of the commissioners on what role oversight in the briefing. And so, you know, are you just there? Do you have the powers? And so I just wanted to highlight that the ID, similar to DPP's, has powers in terms of Section 20 of the NPA Act. And if I'm just allowed, commissioners, so the first part of the powers are powers accorded to all prosecutors and heads of the prosecuting agencies, which is the power to institute and conduct criminal proceedings. And that in terms of Section 21, the power is contemplated in Section 179(2) and other relevant sections of the Constitution to A, institute and conduct criminal proceedings on behalf of the state, B, carry out any necessary functions incidental to instituting and conducting such criminal proceedings, and C, discontinue criminal proceedings, vests in the prosecuting authority, and shall, for all purposes, be exercised on behalf of the Republic. Those powers are also applicable, commissioners, to the investigating director. When we were talking about briefings on matters, there can be briefings on matters. And in Section 29A of the NPA Amendment Act 10 of 2024, if I could just relate to those powers and functions of investigators. An investigator.
Sorry, Advocate Johnson. So has that amending act not been inserted into the main act? Is it a standalone act?
It's a standalone section, as I find it, Chair.
I'm asking because there will be ABCD Amendment Act to blah blah. But when you go through it, you find that it inserts sections, new sections, or adds to existing sections into the main act or the act that it is amending. So are you saying that's not what has happened here?
No, this relates to a different power.
Chair,
yes.
If I may, our version of the NPA Act has inserted 29A. That the witness references, and it was inserted by Act 10 of 2024.
Yes.
So she may very well be reading the Amendment Act, but it has since been inserted into the main act, and it's to be found there. Thank you.
Okay. All right, please go ahead, Advocate Johnson.
It's just to indicate Commissioner's powers and functions of the investigators. 29A, subsection 1, an investigator may, subject to the control and direction of a head of an investigating directorate, exercise such powers and must perform such duties as are conferred or imposed upon him or her by or under this act and any other law, and must obey all lawful directions which he or she may receive from a person having the authority to give such directions. And then it goes into the powers that the investigators may have, which is search, seizure, arrest, execution of warrants, securing the attendance of persons in court, the service or execution of subpoenas, and the investigation of offenses. It is in the briefings that we receive that it is usually these operational matters that are discussed. And so investigators may be subject to the control and direction of the head of the investigating directorate. But when we read back with Section 20, these matters are still incidental to prosecutions. And so if the investigating director disagrees with anything, I have the authority to then say, this cannot proceed, this must not happen, and or as I indicated earlier, you have to correct this. If we do not have it corrected, there's insufficiency of evidence, it cannot proceed.
Okay. So you add this in response to a question as to what the function of oversight function entail and the powers you have over decision made by investigators. So, and if I understand you correctly, where we land is that, do we land at a place where now we understand each other that you have the power to override their decisions?
That is correct.
Okay, thank you. Duly noted and added, was that the one issue you wanted to highlight in regard to the second statement?
That is the issue.
Then that takes us to the third statement. You recall when we referenced this statement in the morning, I did indicate that there are certain issues arising therefrom, and these involve the question of you as a witness responding to questions, the answer to which you believe would incriminate you.
Correct.
So I had suggested that we work through the statement first in its entirety before we address the commissioners about what my engagements with Mr. Bodlani, where they landed us, and to hear your attitude towards that. So for the moment, let's deal with the contents of the statement, then we'll deal with the principle, whether or not certain questions can be put to you. And my understanding, this statement is dated the 20th of July, which is yesterday, and it was filed in response to a Rule 3 issued following the testimonies of 3 witnesses that appeared before the commission last week Friday.
That is correct.
Yes. Now, not last week Friday, the Friday before. For ease of reference, I'm going to give you a copy of the Rule 3. Mr. Bodlani?
Chair, before the adjournment, Advocate Johnson was asked to look at the transcript of her testimony before the ad hoc committee and to check whether she raised the sub judice issue there. Yes. The suggestion being that it would be quite odd if she didn't raise it there and then she would come here and seek to raise it. I think my colleague has forgotten about that issue because she's now going to the third statement, and it's an issue that arose when Advocate Johnson was dealing with the second statement. If I may just place that reminder before you.
Thank you so much. That's quite correct, Chair. I'd even referred Advocate Johnson to where the transcript is in the Exhibit 5.
Thank you, Mr. Bodlani.
Thank you. Advocate Johnson, you had Advocate Bodlani. I take it that you, in the course of the lunch adjournment, you had opportunity to have regard to the transcript, and then you can refer us to that part of the transcript where you are dealing with the issue of sub judice, if at all, before the ad hoc committee. Thanks. Commissioners, as I indicated, that is
File 3.
Yes, File 3.
And I'm at page 621.
That's correct. CJC 375. Thank you. You may start.
So on the question of the sub judice, it does start at the top of page 621. That's the number I have, where Mr. Mngango, he said, when you speak of, and I quote, capture for private interest, are you referring to financial gain, manipulation of investigations, or influence over personnel and procurement decisions within CI? Advocate Johnson, it is the third one. Mr. Mwango, you also indicated that you can expand more on this matter before the committee. Could you provide specific examples or case references that illustrate how these systems were captured or manipulated? Advocate Johnson, when I said I would expand more, it was in reference to the chart sheet that was attached and those parts that I referred to that I can talk about. The rest of it I am unable to expand on. Those matters are in court and sub judice. And that is where I found, I think for the time that that is where it was, in fact raised.
Let's just be clear, Advocate Johnson. Did you say in the ad hoc committee that you will not respond to these issues because they are sub judice? Or you simply said in response to that one question, you cannot expand?
I read it as to that question, I would not respond.
So are you saying in the ad hoc committee you never responded to issues relating to Brigadier Mokwele's appointment and the subsequent charging of the 5 or 6 people involved in that? I'm sure you remember, even without going.
I am
through the
sure that I
transcript.
did answer questions.
You did, so
Yes.
you had no difficulty answering those questions.
No, it was in the manner in which the Honorable Mwango
Yes,
had posed a
had
question,
posed the one
and I raised that issue.
So to be fair to you, can we leave it here that you will respond to questions, but where you feel that you cannot respond to a specific question, you will invoke your right as you wish on a question-by-question basis so that there is no blanket refusal to respond to these questions?
That is correct.
Are you comfortable with that?
I'm comfortable.
Thank you.
Commissioner Kumalo, just a point of clarification. It takes us back to the application where sub judice is involved. And I had understood when we started the stream that that issue has been disposed of. So before this commission, that rule is not available to her. Whether or not she can answer to a question as and when it's posed to her is in the context now of the third statement, which relates to the question of self-incrimination. Those are two distinct issues. Just so the witness doesn't, I don't confuse the witness and suggest to the witness that she may invoke the sub judice rule in relation to any issue put before her, because that has been disposed of by the commission. But that is distinct and different from the issue of self-incrimination. I just wanted to make sure the witness and I don't talk past one another on this point because it is quite important.
Yeah, no, I think because the witness was responding to me, you can address her separately. I just needed to understand what her current position is.
Yes.
And that was not a ruling by myself or by the chair. It was simply me seeking clarity from her. And my understanding of what she said is that she invoked the privilege in relation to MP Mwango's question.
Yes.
But then she continued answering questions, so she did not have difficulty answering questions. And she may or may not, depending on what question is asked, then raise the issue. So I left it there on the understanding that we can ask her these questions and she will respond to them. And where she does raise an issue, then it will be dealt with there. But that was in response to me. So don't understand it to mean that that's how the matter ends as between you and her. No.
I understand that, except that Commissioner Kumalo, then it takes me to the ruling by the chair when we started regarding the issue of sub judice. To remind us all, we indicated that we've been finished with 4 dockets. And the agreement between IDAC's legal team and ourselves was that the 3 dockets we will refer to extensively and with a no holds barred approach. There's only the 4th docket, the one that on the basis of which We now learn that General Khumalo was due to be arrested on the 16th of June 2026, thereabouts. We will exercise restraint only insofar as that particular docket is concerned. And that would not be on the basis of a sub judice rule, but more on the basis that that docket still involves extensive investigations, and we are quite sensitive that we do not undermine ongoing investigations. Where that lands me is that my understanding, at least, insofar as IDAC is concerned, is on the matters that will be traversing with any witness from IDAC, the sub judice rule doesn't even find application. And I just want the witness to understand that that is where we landed. So I do not expect a response, or I don't think the commissioners would expect a response from the witness that she cannot answer because the matter is in court. That issue has been settled. The only issue that is outstanding is a self-incrimination issue, but that is the subject of the third statement that we are going into. Do you understand my position, Advocate Johnson?
I do, Counsel.
Okay. I think I'm clarified. So, is that when you referred us to the transcript, is that the only place you found where reference to sub judice
Yes,
is
in the
made?
time that I had, that was the one that I could recall. And
then as Commissioner Khumalo points out, notwithstanding what you stated, page 621, that you are unable to expand on that as those matters are in court and sub judice, you proceeded to answer questions relating to those matters.
Correct.
Before ad hoc. So in fact, much as you raised it, you did not seek to assert it fully and insist that the rule be respected throughout.
correct.
Thank you. Okay. I'm indebted to my learned friend for reminding us of that. After a heavy lunch, I think, are there any other issues that perhaps you were to consider during lunch, Advocate Johnson, that you would like to bring to the attention of the commissioners before we go to your third statement?
Commissioner Khumalo had asked that I look at the statement of O'Sullivan at paragraph 1.8.3, which I did. And I do see what he says, but I can only recall a complaint that came from the Office of the Minister as well as Adams Section 27. I can't take that paragraph further than what it states in 1.8.3. Just to indicate, Commissioner, I did read it. Thank you.
Thank you. Then I think we're ready to turn to our third and final statement that appears under tab 3. As I indicated, it's dated the 20th of July, 2026, and it's a 5-page statement. You deal, the crux of the issues are from your paragraph 5, and to this end you reference the Rule 3 notice that you received following testimony by Colonel Rule of Say Captain McLean at Witness O. You do not adopt the ad paragraph approach in that statement, but we have availed a copy of the Rule 3 and the issues you were called upon to respond to, which you seek to do in this particular statement. So when you are ready, I think you can safely say you can skip paragraphs 1 to 4 as they reiterate what you already have stated in your first statement and repeated in your second. So if you could take it from paragraph 5, thank you.
Paragraph 5, Statement 3. The notice requires me to deal with allegations against me testified to by Colonel Kobus Rulofse, Captain McLean, and Witness O. The allegations, as summarized, implicate me in alleged criminal conduct. 6, the allegations are contained in a docket which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. That this is so was confirmed by the NPA on 10 July 2026, as well as by the witness McLean when he testified. Now that the matter is before the NPA on the basis set out above for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of the need for me to have my rights protected. Paragraph 8. Thus, when I testify on those matters, should I be called upon to, I will exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. 9, I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances. For these reasons, this affidavit is submitted to place my position in regard to the testimony of the witnesses identified above formally before the Commission. Also, I take this opportunity to correct certain assertions, and those were then dealt with already, Advocate Selo, that is 10.1, 10.2, as well as paragraph 11.
I confirm. Thank you.
In summary, apart from correcting the errors identified above, this affidavit records my response to the Commission's latest notice, confirms that the allegations against me are already before the NPA for a prosecutorial decision, asserts my constitutional and statutory right against self-incrimination. Accordingly, I place this affidavit before the Commission to preserve my constitutional rights, to avoid any unfair prejudice arising from parallel prosecutorial processes. Conclusion. Lastly, I see the need to state, paragraph 14, that prior to my then scheduled appearance on 13 July 2026, I took ill and did not appear before the Commission. I placed before the Commission a medical certificate on which a dim view was taken. I have since approached my doctor for the preparation of what I believe is a medical certificate that would be acceptable to the Commission for its details of what led to me being indisposed. It will, together with this affidavit, be delivered to the lawyers of the Commission. I request that the medical condition I suffered from not be made public. Should I be required to answer questions flowing from this affidavit and other matters in respect of which it has been determined that I would be of assistance to the Commission, the same of subject to timeous notice and the right to legal representation, I would be willing to make myself available for such.
Thank you. Thank you, Advocate Johnson. Is there anything else you would like to add to this statement?
Chair, there was a bundle that came last night, and what I saw in the bundle was there was WhatsApps of Barry Bateman, and there was, I think, an affidavit of Brigadier Petle. I know my counsel struggled to open it, so we were not able to consult on those matters, and I do not want to be seen to be leaving them out because they do relate to the same matter. So if where I'm talking only about 3 people, I open myself up to questions from others who all relate to the same matter. And if I could just take a minute if I could confer with my counsel through you, Commissioner, just to see if they were able to get to that bundle, because the first part, Advocate Selo says bundle, and then it has those names. I don't want to miss a name that might be there.
May I suggest this perhaps might assist you? You recall during the course of consultation, file 1 of the exhibit bundle was shared with
Please,
yourselves.
the mic, please.
File 1 of the exhibit bundles was shared with you. This is about 10 days ago to 2 weeks ago. Do you recall that? And in that bundle 1, at annexure 368, CJC 368. So those documents in their entirety were shared with you. And I'm trying to understand which bundle you received last night regarding the sharing of the docket with General Khan.
This is a very similar. We also got one last night at 1912.
It could very well be updated documents or additional documents to the exhibit, the main exhibit bundle, which by now runs into 7.5.
Yes.
But I'm interested in this particular bundle 1 and say you received that bundle 1 in its entirety about 10 days ago. If you look at exhibit bundles from page 1.
Sorry. Is this something you'll be dealing with? Oh, by the way, you still want to get an idea of what it is, so you may not be able to answer my question. But perhaps in fairness to Advocate Johnson, she has to confer with her counsel. Mr. Bodlani, do you want us to stand down for maybe 5 minutes, give or take, or do you want to walk across and?
Thanks, Chair. It might not be necessary. As I understand it, Ms. Johnson's issue is there are documents that we received yesterday evening.
Yes.
In respect of which we didn't have an opportunity to consult with her. I don't know if my colleagues for the commission intended to ask her questions on those documents, but this morning we were subsequently given those documents physically. We couldn't access them in electronic format. I am able to point out now that we've got the physical bundle. From what page to what page have we not been able to talk to Ms. Johnson about?
Yes.
Now, if I point those documents to my colleagues, they might be able to tell you that they don't intend to traverse them this afternoon at least. Okay. Then that way the issue is resolved.
Perhaps let's just go out and we'll come back when it's indicated to us that we should.
If I may, before we do so, and that is the clarification I, to some extent, was seeking and was highlighting to Advocate Johnson. The bundle grows literally on a daily basis, so that there were documents provided to the team and to the witness yesterday is possible, but those would be in file 8. The issues that Advocate Johnson addresses in her third statement are the start of the exhibit file. Which is from page 1, and that was provided to her 10 days ago. I just mentioned that in the context of the request she has made to confer with her counsel, just to make sure which documents we are talking about.
Can we just have that quick stand down? You'll indicate when you are ready, Mr.
Certainly, Chair. Thank you.
Yes.
Thank you.
That's Jen.